human security. As we know, the concept of human security was born in 1994 with the Human Development Report and includes two major components: the freedom from want, as other scholars underlined before, and the freedom from fear, in the sense that the policies of the state should aim the achievement of the secure life for the proper citizens. The exact intention of this survey, of this paper, is the other dimension of the human security, which is the external dimension, which regards and concerns the relations between the actors or the subjects of the international law, in other terms the states, and the use of the force in the international relations. The reason stands on the fact that recently we have a return of the armed conflict in different areas of the world. Just to mention Eastern Europe, Northern Africa, the so-called Arab Springs, and the Middle East, involving not only the area countries, but also Occidental powers, which made consistent use of force in these geographical areas. The prolonged Israeli-Palestinian conflict, the wars in Afghanistan and Iraq, the suicide and bloody wars in Syria and Libya, the unacceptable Russian-Ukrainian conflict are just the examples of this trend in the international relations and the unproportional use of the force in the international relations. What is the legal basis for the use of the force in the international law? Article 2, paragraph 4 of the Charter of UN Charter is the so-called biblical legal reference for the prohibition of the use of the force among the states in their relations between each other. It was a positivization of a rule already existing of customary international law, which had assumed a conventional and positive force by implementing it within the first part of the UN Charter. In order to reject the use or the threat of the force against the political independence or territorial integrity against any states or not in conformity with the Charter. This is the general norm regarding Article 2.4 regarding the use of the force in international relations. The prohibition is absolute, but this doesn't mean it doesn't accept any exception. The exceptions are grounded partly on the UN Charter, namely Article 51, individual or collective self-defense, and partly on Article 42, the so-called Chapter 7 of the Charter. According to non-conventional, so outside the borders, the limits of the UN Charter, according to customary international law, we can also underline other exceptions of the use of the force in particular circumstances, which is necessity, fortuitous case, force majeure, distress or the extreme danger, or the approval of the entitled subject. There is also, and I would like it to mention in the other slide, a reason theory born in the 70s with the appearance of the so-called erga omnes obligations in case of paralysis of Security Council decision due to the veto imposed by a member state's permanent member state. Any state or a coalition of states can act ut universi on behalf of the international community against another state found to be aggressor or to use the force without any legitimate base. But in this case, the intervention should meet the criteria as sanctioned in the Chapter 7 of the UN Charter, until the Security Council of the United Nations is involved with the question. Article 51. Which are the criteria for individual and collective self-defense? The armed attack has to be occurred, has to be actual, and at least imminent. And the reaction of the entitled state or coalition of states, if it treats about the common intervention, should be necessary, immediate, and proportionate. And the only aim it should achieve is the prevention or the interruption of the attack perpetrated by the offender state. So, in the recent conflicts has appeared a new form of armed intervention, the so-called pre-emptive or anticipatory self-defense. Is an invented terminology advanced by some countries, some states of the international community, which could not otherwise legitimate their proper use, the proper use of force in the international relations. There is a quite difference between the notion of preemptive or anticipatory self-defense and interceptive self-defense. What does it mean? Preventive self-defense falls outside the borders, the legal borders or legal limits of the Article 51 because of the non-fulfillment of the first criteria. The attack has not occurred yet. So this is preventive. It is about a preventive attack by the supposed suffering state or attacked state. And these two kinds of, we can go not back, sorry. Two kinds of categories of intervention, anticipatory intervention represent also two different schools of thought over the issue. There is an Occidental school of thought, but not only, which legitimates the anticipatory use of force in the international relations. And there is also a minority, but very attentive school of thought, which legitimates the preventive use of force only in cases of interceptive self-defense. Had, for example, the Japanese, during the Pearl Harbor in the Second World War, which caused the join of the American Army in the Second World War, had the Japanese carrier striking force been destroyed on its way to Pearl Harbor, this would have constituted not an act of preventive, but a miraculously early use of counterforce. So the minority school distinguished the interceptive self-defense as an early use of force. The self-defense exercised in this case by the United States in response to an armed attack would have been not anticipatory, but interceptive in nature. We have three cases. I took under exam three emblematic cases of use of force in the preventive or preemptive sense. The Cuban Missile Crisis of 62-63, the Israeli-Arab War of 67, the 6 Days War, the so-called 6 Days War, and the Oz-Iraq bombing. Oz-Iraq bombing, the nuclear reactor in Iraq, bombed in 81 by the Israeli military forces. There is a quite concordance in the doctrine as well as in the practice of the states to condemn the first and the third case of intervention because considered a preemptive use of force. While in the second case, in the Israeli-Arab wars, when the Israeli Air Force destroyed completely the Egyptian Air Force, they just anticipated the imminent attack of the Egyptian armed force. In other two cases, we have also the reaction of the Security Council in the resolutions against Israeli and United States during the two involved cases, which firmly condemn such actions, closing definitively the door to the preemptive self-defense in absence of the occurred armed attack or short any imminence of it. The doctrine of Occidental doctrine of preemptive use of force assumes a further dimension with another one, with 9/11 terroristic attacks. The American administration of the time also adopted a national security strategy addressing the question of the new issues challenging the security of the United States, mostly with concern to the terrorism. The strategy became a handbook for the Bush administration on the global war on terror, against terror, in all the areas where the American army was involved in armed conflicts, making continuous use of the preemptive or anticipatory self-defense use of force. Also, beside this doctrine, another theory was born, the so-called Pinprick Theory, or the accumulation of small-scale armed attacks, which, according to the American administration, gave the right to the American army to react within, according to them, within the borders of the Article 51, so to prevent preemptive self-defense. For the concern of the present survey, I should underline that such theory is in a clear violation of the core elements of the self-defense institute, namely the proportionality, the necessity, and the functionality. If we don't have a human security at international level among the states, we couldn't achieve a human security for the individuals within the proper territory and the state's jurisdiction. Thank you for your attention.